dear all, thank you so much for joining us today. I will move to Russian just in a few words. I just wanted to thank the organizers of this event, Arbitrating Through the Thorns. I think all of us, all of you who experience, who now practice arbitration in Russia understand what it does mean, I mean, through the thorns. And I just wanted to thank our dear co-organizer, Horizons & Co law firm, and our colleagues from this firm who came to Moscow to join our event in person. And of course, I also thank the ICRC library, this wonderful place, for hosting our event today. I will give a floor to Mr. Rodrigo Care, who is a senior associate at Horizons & Co in Dubai, and he's a very experienced international arbitration lawyer with experience in different arbitral institutions, including ICC, DIAC, and others, just to make sure that everything works well. I will remind you that we have interpretation sets, and if you need one, please take one. It is here. Thank you so much. I give the floor to Rodrigo to start the session, and I wish you a pleasant day. Thank you.
It's okay. Thank you very much, Julia. It's really a pleasure to be in Moscow with Adel Zaroni from Dubai. So the purpose of this section will be to discuss how can Russian parties deal with agreements, arbitrations which are in place, or contracts which have been signed some time ago, before the current situation, and the difficulty that Russian parties have in finding international lawyers on which they've been relying on for such a long time. And today we are a scenario where the dispute resolution framework is changing, and we have seen in Dubai a lot of interest in Russian parties in using other jurisdictions, exploring other options, and how those options can be used not only for the future but also for the current disputes. From that interaction, I will give the floor to Adel Zaroni, who is the chairman of Horizons & Co, and who is one of the most prominent arbitration lawyers, litigation lawyers in the UAE, and has over 20 years of experience. Ali, the floor is yours.
Thank you, Rodrigo. Good afternoon, everybody. Thank you, first of all, to RAC to invite us to be hosting or co-hosting with them on this nice audience. I can see them, and in Moscow, which is I personally love Moscow even before sanctions, so it's nothing to do with the sanction. So I'm really happy to be here with lots of prominent colleagues and speakers with me here, and thanks. It's a pleasure for me actually to talk to every practitioner on the arbitration. So starting with the change happen on the world and the legal field, there is a lots of change happen. Our profession, people always look at how's the impact of the politic on the legal sectors. That's showing today for the fractions today is in the world related to the law and how to implement the law and what is the rules of law. I remember I have my daughter, she's studying law in the college, and they always telling them that the rules of law is always prevail. Unfortunately, I have to tell her now, I don't think that is correct. You have to go and challenge your professor. That's happened, but with the change, with that sanctions and sanction regime against Russia, that's create a different situation on the world. Difficulties for our lots of companies in Russia to operate. Of course, our colleagues, also friends on the legal field here, creative enough, of course, to find or navigate between this, and they are doing a great job, as I can see. Coming from UAE, United Arab Emirates, is a country which hopefully most of you guys know it. It's not large like Russia, but it is a small, tiny countries comparing with you guys, but it's very active countries. We have a federation of 7 emirates, and that's make us having a unique position on the market there, on the region. So we are situated in the middle of the world mostly, and there's Dubai. It's very well known to be a center of a lot of business. With the sanction issues happened, of course there was a lot of shifting of the business happen on the many of the companies to find out a way for doing their business. Of course, to do that, you need to have a right country with the right environment, business and legal. That it was the everybody was searching. What is the way forward? How we can manage that? So UAE, in a political level, they already announced that we are a neutral country, so we don't want to be involved on that fractions or that tension, let us to put it this way, and they decided to be a neutral. Saying neutral, that means they are welcoming everybody, and which is, we see it as a practitioner in UAE, we see it that's happened, and lots of business people, lots of lawyers come and meet us there in Dubai, which I was actually very happy to see a lots of good lawyers coming from Russia with a high caliber. That's happened. Then the business, most of the legal practitioners, they start thinking, okay, why we should advise that UAE could be a good country for being a hub for the Russian business, for a hub for the dispute, and there was many of the questions about that. So my answers was very simple. First of all, when you are coming with a friendly country, that is something which is a positive. That's first thing. Second, UAE has what we call it hybrid system. So we have a court which is dealing with a civil law system, and we have which is the onshore court. The offshore court, which is we have it on 2 financial center. It's dealing with more or less it's a law which is taking from a common law system, but it is not. But it is more or less very similar. Saying that is about the court system and about the laws there. So colleagues from this region, they well known about the common law, and they know how it's operate. They can find themselves, it's a good place actually to see how the DIFC or ADGM in Abu Dhabi could work for their dispute in the future. So there was many of seminars we conducted from last year's debating about why should the people go to Hong Kong or Singapore or other centers, why is not Dubai? Because I see that Dubai is having a lots of good potential, business-wise, legal-wise. We have that hybrid system, which is very less countries they are having that. Also, we have a nice arbitration center, which is very well known, and it is last 2 years actually they modernize it and they make it a new law, which is taking mainly from UNCITRAL rules, which is very well known for lots of practitioners. That's saying that also that law is also giving the default seat to DIFC, which is that means it's you can apply DIFC law, which is similar to common law. So there was a lot of talking about that, and I see comparison with the other countries and centers for a dispute. I can see it that could be a a positive place. And talking about the welcoming of Russian business people, I think the practitioners, they are aware that there was a very much welcome, lots of people, lots of companies, and there is many of them actually today time actually thinking to develop much and more, to be more settled on our region, because they saw that it's safe, the system is there, they can grow, they can find a new market from Dubai itself, or from Abu Dhabi, or from any other of Emirates. That is make us actually telling all our practitioners, I think you need to put more focus on the DIAC, Dubai Arbitration Center, and also now we have RACers already. They have a branch, or they have a spot on the DIFC. So that could be also a good positive thing for Dubai, because I remember when they told me the first time that they are applying on DIFC, I said that's a good move. It's actually a clever move to come quick and act quick, which is because in UAE we have ADGM is hosting ICC, but DIFC used to have LCIA, which has been abolished and then has been merged. Now it's all concentrated on the IAC. So which I think that there is a good platform available for most of the practitioners to advise the client. Either they will go with the DIAC or even RAC. They are there. They can take it, the seats there. Maybe that will help, because that will get you a different. Plus, UAE actually is a country who has many bilateral treaties for enforcement. So anything will be done there. The enforcement will not be difficult to do that, because it is an acceptable and enforceable decision which has been practiced or previously, whether it was a DIFC court, whether it is the arbitration through DIAC, and now it's much better because you don't need to go through the local onshore for ratifications process. You can go directly for a DIFC court, and DIFC court just rubber stamp it and enforce it for you. That is make it solutions for many things. I know it's not easy. Always changing the dispute resolution is not easy for especially for historical agreements which is already there. But I think that's something which the practitioners should think about it, because they don't need to be hostage of some centers which either they are not welcoming, or they will be very big doubts that they will be fair with the Russian companies. That's something which we encourage people. You have to come and more look at the system in Dubai and see it if that will suit, and then advise the clients. That's something which I'm really thinking positively about it, and as a country, I can see it is always welcome and always looking to the business people there. And actually, the country is pushing also that's our business people to have more partnership with lots of Russian companies there to continue doing a business there, and not to be as a only step for them for a permanent time. The country, they want them to be for as long as they wish to stay there to continue doing the business. So that's say this, and I think so Rodrigo is keep alarming me every time, 1 minute, 2 minutes, 3 minutes. So I finish it here, and I will leave my colleague then after that.
Thanks a lot. Thank you very much. Our next speaker is Mikhail Demin, who is legal advisor to the chairman of VEB. We'll follow this conversation, seeing what is the point of view of in-house lawyers, in particular in dealing with the current situation, and how in-house lawyers are reacting in the problem in hiring counsel, problem in pursuing a dispute the way it was planned at the time contracts were arranged. Mikhail, the floor is yours.
Thank you, Rodrigo. Can I please, in the first place, ask for your guidance? Can I speak in Russian or should I speak in English? What would be the preference of the audience?
I think so. Yeah, I have a translation.
Russian will be fine? Okay. Хорошо, спасибо.
Okay, thank you. Thank you.
Спасибо большое.
Thank you very much, Rodrigo. Thank you very much, dear colleagues, for this meeting. What should I say on behalf of one of the Russian state corporations, the Institute for Development, which historically was quite active in external business affairs? Well, yes, indeed.
Такого, в общем, инерционного использования
the practice of use of LCIA and the centers that we would always use for dispute resolution, especially arbitral centers. Well, now we see the other side of the coin of their work in 2022, and we continue to see the same.
Да, действительно существует.
Yes, indeed, there are difficulties
возможности защищать
to defend our interest in European and British arbitral institutions, and we see such difficulties mostly in the attempts to hire international consultants in London and Europe, and we see difficulties to just make a payment, to pay the administrative fee and some other payments in the proceedings at the arbitral court and also in the arbitral tribunal. And also there is another issue here, everyday issue. It takes a huge amount of time to address very simple things, everyday things. And also we are aware that for a while we will have to live with what was signed some time ago, and also there is an increasing number of reasons for court proceedings every day, and also we are just waiting for dispute flow actively in mid-2023, and we were quite pessimistic. Still, we all understand that the obligation established by our Russian law to comply with the obligations towards international companies to make the payments, etc. So it's binding and should be enforced. And our contractors can never agree to this delivery of our obligations, and we are waiting for a flow of different claims for international arbitral centers, and also LCIA and ICC and other European arbitral courts. And there is another intrigue here, and it would be very interesting to see the outcome. Ours being a party, when we're interested in court proceedings, of course it's difficult to go to a European court. I mean for example, arbitral tribunal in Europe or in Britain to just initiate the proceedings. If we are a defendant, the situation will change, and also our partner under the agreement will be interested in proceedings against us, and there'll be an intrigue here. It would be interesting to see whether the change of site of arbitration will be used, and we will have to change the location and change it to Dubai or to Russian Arbitral Center and so on. This is the intrigue for the next future.
So far, indeed, there are certain difficulties, but that is when we act as a plaintiff. As for further agreements, further contracts, and possibility to carry out activities, certainly here we appreciate the stand of our colleagues from Dubai, from China, and it is when it comes to our further activities, it's very important to select a location for arbitration proceedings very carefully and very consciously. And of course, we have to consider a large number of factors, and that is what we need to keep in mind as we take a look at our arbitration clause. And of course, we should not forget about all foreign countries, BRICS countries, and namely BRICS countries, countries of the Shanghai Organization of Cooperation. These are the countries that cooperate with Russia very actively at this point of time, and we really welcome the initiatives of let's say, Russian arbitration centers that open their branches, their presence in foreign jurisdictions, those jurisdictions that continue cooperating with us, like in Dubai. That's what I wanted to share. Thank you.
Many thanks, Mikhail. We will now move to the next speaker, who is Andrei Gorlenko. Andrei is the head of international dispute resolution at Ivanian and Partners, and is also the head of the Russian Arbitration Center. We'll follow this conversation, seeing what is the point of view of the Russian lawyers, the Russian legal community in dealing with the current difficulties. Russian lawyers were used to work with the International Council, were using to run arbitrations in foreign jurisdictions, but today the scenario has changed. So, Andrei, can you tell us how Russian lawyers are reacting to that situation?
Sure. Thank you very much, Rodrigo. Thank you very much, Ali, Mikhail. It's very good we're very happy to have you here in Moscow. I will continue now in Russian because of the audience. Please, apologies. But I would be with pleasure speaking English. So we'll switch to Russian now.
Actually,
являюсь таким своего рода emergency спикером.
I'm an emergency speaker. Initially, my participation was not planned, but that actually highlights the importance of this topic and complexity of the topic and the current conditions under which we find ourselves. And they're quite challenging, especially when it comes to discussing the existing contracts, the existing clauses, the existing relations with the foreign lawyers and existing disputes. Actually, I'm thinking about spring 2022, and it's no secret that back then a number of members of the Russian Arbitration Center representing foreign countries had to exit the Russian Arbitration Center. We have not discussed that before, but I should say that it happened in a very courtful manner, and they called me as the head of the presidium of the Russian Arbitration Center. I will explain to you why I'm thinking about it. I remember one of the arbitrators called me a very respected person who has very warm feelings for the Russian Arbitration Center as well as for the entire country. And he called me from far away and he asked me, Andrei, how is it going? And how do you feel under the current sanctions? And I could feel lots of empathy in his voice. And, you know, I told him, all in all, things are going well. And, you know, I went to buy coffee and he used to pay with the phone for the coffee, but now you always need to have your plastic card whenever you want to pay. And basically, these are all the changes that I'm experiencing. Probably I'm exaggerating a little bit, but I think it's very typical for our profession to feel upbeat and to be able to cope with difficulties. And even under most challenging situations, we are able to look for ways out, look for solutions, and we are quite proud of it. But that is really true, and we are able to adjust, we are able to find solutions, and thank God human relations have not been cancelled, and they are very important today. And as Mikhail said, it would be good to spend less energy and time on administrative hurdles and spend less energy of our clients on overcoming administrative hurdles, and rather be focused on settling the dispute instead of being bogged down in administrative aspects. But there are certain benefits in this situation as well, because after this inevitable process, we have come up with a lot of new friends, and we had to rotate the presidium of the Russian Arbitration Center quite significantly. And the fact that this event takes place today, it is related to the changes because we started working very actively with His Excellency Mr. Shavalehi, who is in charge of the arbitrational proceedings, and he actually introduced us to our great colleagues from the Horizon and Company, and it was his initiative to have our office registered in Dubai. And at this point of time, you understand that the world is great and it's huge, and you know, when the judge is when the judge demonstrates such great attitude, and you see that there are lots of great experts working there, and they understand the all importance of the image of the foreign jurisdiction. They understand how important it is to make effort to retain a great reputation, and therefore I should say that there are advantages in this complex situation, although, as I have said, we often try to look better than we are, and we are not so focused on the negative side. As for the existing disputes, there are several categories of them. First is when the dispute has started in the turbulent period, and I do have several disputes where I'm involved, and of course, if your client is under the sanctions, in that case, the lawyers, even Western lawyers, agree to participate in the proceeding and represent the interests of the clients. And this week, for instance, we take part in the proceeding taking place in London. And, you know, last week we were trying to have several witnesses go to London so they would participate in person, so they would have a direct contact with the arbitrators. However, when it comes to issuing a British visa, that can take lots of time. Therefore, the hearing took place online. Thank God we have this opportunity to get in touch online, thanks to the pandemic for that. So the witnesses, some of the witnesses were in London, some were in Moscow, and despite the fact that some of our witnesses were in a different time zone, they still were able to connect. And, you know, if still they could have get the visas, would you want them to take this roundabout way and go to London via Istanbul and just for, you know, being there personally for several hours? So maybe it still would make sense to stay here in Moscow and be in a very good shape, physical and moral. We also can say that one of our arbitrators got sick, and we had to choose a new arbitrator in an unfriendly country in a very narrow niche, and very few arbitrators work in that field particularly. And you find yourself in a situation when you don't know what your arbitrator thinks, and we understand that we all live in a media-biased world, and you don't really know what that arbitrator thinks about your country and what can be that last drop that will change his mind. It can be a headline from the newspaper that can, you know, make him feel kind of biased, because there is a huge pressure of the modern media. And my foreign British colleagues offered 3 arbitrators, and we said no to one of the candidates, because after a personal talk with my colleague, I found out that arbitrator felt quite negative about Russian jurisdiction, and maybe he would not say, and maybe it could be different at this point of time. However, I received that knowledge, and that impacted my decision. But you do not always have a chance to receive insights like that. As for the current disputes, I can say that when it comes to existing contracts, you need to make an audit and include some of the clauses. It's not always possible to do it, but at the same time, when you understand that if you are coming to a pre-stage of the proceeding, you need to analyze and decide where the allocation of the arbitration would be, because after all, you would want to represent you want to present your colleagues, your clients' interests, and if it's a partial award, you will have to engage the local lawyers at the pre-stages. You also need to look at the requirements for the arbitrators, and you also need to understand where the enforcement of the award will take place. You need to understand where the assets of the defendant are located, and maybe you have to think about it beforehand. And the smaller jurisdiction is, the better it could be. And sometimes it's quite difficult to find good consultants, and after all, a legal community is not huge, and some of their colleagues are not willing to work with Russian companies. And sometimes, if there is an opportunity to come to terms and to discuss additional clauses, it makes sense to do it. And but how to do it, that probably would be the point of discussion for the next sessions. Thank you.
Many thanks, Andrei. We'll now have a round of discussion with the panel, and we'll then hand the floor to the public for question. So I think the topics touched by just now by Andrei in finding foreign counsel and dealing with contracts using foreign institution and having in mind where arbitral awards was enforced keeps to my mind the recent case in the courts of St. Petersburg, where the Court of Appeals said that Hong Kong international arbitration does not comply with the requirements of Russian law. I'd like to ask to the panel as to whether there's been discussion about that particular precedent, and how do you take that in account, for example, in choosing the DFC as a forum for disputes. Andrei?
Thank you for the question.
Благодарю вас за этот вопрос. Thank you
Мы,
very
конечно, все
much.
внимательно следим за этим
Actually,
делом.
we are following
Я
that
понимаю,
case
вопрос только
very
первой инстанции.
closely. I understand that the
Не
first
хотелось бы, честно
instance
говоря,
has been
как-то,
just finished, and I would not want to comment it before any
вышестоящих.
court acts and the higher instances will be issued, because it is a very complex matter. The arguments of the court, I will put it very cautiously, is can be discussed, and it can. Some may agree to it, others will not. But definitely, it's a ring of the bell, and it may be a marker of unfriendly jurisdiction, but also belonging to a certain system, and that can
В российской юрисдикции
raise
в текущих условиях.
questions under current conditions. We don't know for how long it will last, whether this practice will extrapolate. I think it's too early to make any conclusions. At the same time, when it comes to enforcing an award not only in Russia, then probably it will not have large significance. In any case, we have to follow this case very closely, but in any case, everyone should make a decision with the account of their information available. Thank you.
Thank you, Andrei. Mikhail?
Да, спасибо большое.
Thank you very much.
Хотелось только, наверное,
You know, I can add that the current situation
заставляет
makes us look at approaches in a different way. And as you think of the arbitration proceedings, our practice of selecting arbitrators and what to do with our strategy when it comes to the existing disputes, whether we should use or not to use a Russian anti-suit, and that is actively discussed in the legal community at this point of time.
Если как бы сторона, находящаяся в судебном разбирательстве или в потенциальном судебном
if the country that is engaged in the potential proceeding understands that it has very few chances to initiate proceeding abroad within the framework of the foreign arbitration tribunal, this party may be tempted to go to the Russian court and receive the decision of the Russian court that prohibits the other party to carry out any proceedings abroad. And the other party has very good chances to receive anti-suit against the Russian party, but also against the management, with the threat, contempt of court, and so on. And here there is a very nice competition of anti-suit injunctions, and in this regard you think what to do, and it's very interesting what the managers of the legal department are likely to do. It's a very philosophical manner. Some of the organizations would want to rely on the Russian anti-suit and probably disregard the foreign jurisdictions, while others would not want to argue with the foreign jurisdictions. But then in that case, the question is what they will do with the Russian arbitration tribunal. So actually, this is a very difficult decision. As for arbitrators, Andrei has said that arbitrators may leave. We had a case when one of their arbitrators left, then the other one did the same. They were all very polite, but nevertheless they dropped out. And right now now we are thinking about forming arbitrage and choosing arbitrators, but in the current political setting, it is quite a challenge to select arbitrators, because you may want to choose an arbitrator that is close to the British or European jurisdiction, or you choose arbitrator from non-European, from not British jurisdiction, but in that case he will be in the minority, and he may not gain a sufficient level of trust from the other two arbitrators that are more closely engaged in the Anglo-Saxon or European community. So it is quite a tough decision, I would say, and I'm not saying that I have any ready-to-go solutions. I'm just saying that beside administrative hurdles related to searching for someone who can help you, especially when it comes to urgent proceeding, you also have to reconsider your approaches to common issues. This is my observation.
Thank you, Mikhail. And then a comment from Ali as a Dubai lawyer as to how the DFC can be framed in that perspective. One of the points that the St. Petersburg court made in respect to Hong Kong is that it is a common law jurisdiction, was a former British colony, and also parties are not able to pay through HSBC, which is the bank that Hong Kong uses. How would that play out in the DFC?
First of all, of course, I can't comment it on the judgment, which is jurisdiction of Andrea and the other colleague, which is out of my jurisdiction. So I don't want to touch that judgment, as Andrea said also carefully. Also, that is still in the court till the court come with a final decision. That will be then the practitioner here, they will start thinking with a creative solution. But talking about an example like that, that's taking the people more towards what I was talking about it in the beginning. That's being in the friendly country with a system which is familiar with most of the practitioner here. I think the IFC could be a very good solution, because their rules, it is very much close to the common law. They have a system which is a nice system. The court is very sophisticated and is nice system, and there's very competent judges there available. So I think that's taking us this kind of sudden decision still to see what the court they will reach. But I think so that's giving the practitioner to find at least the alternative solution ready, because that is take us to what other places could have a system and law system actually to run there on to be chosen place for their arbitration. That's something which is bring maybe the practitioner who is mostly dealing with international arbitration, and they are facing the tough time today with LCIA or other places. Why they should be facing this? That's a question. That's not fair. That is something which is the justice should be given equally for everybody. Anything happen on political level, that's nothing to do with the rights of the parties. So talking about that I see it as that's all take things more towards a solution of DIFC and the systems there, and I think so. I encourage the practitioner here to think more and more about that, because there is first of all the payment when they are not restricting to your guys to the certain payment from the certain banks, so that's not an issue, and the visa can issue quickly, so you don't have a problem. You don't need to use the team calls or anything, which is I don't prefer it actually, because especially if I need a witness to cross-examine, I need them to be there on the room. It's better. They perform better for the clients. And of course, transportation is easy. It's all about the location and what the country they are dealing, and everything, all the facilities actually is available. The court system is very efficient. I think you see Judge Shamlan, which is my friend actually, but he's a very competent judge, and he's really driving the arbitration in a nice way. There is a system. There is the court decision. It's enforceable. That's all things which is, I think, so take us to the positive areas of UAE to be could be as the best solution in the future. Thank you.
Excuse me, may I ask a question? Sorry, thank you. So first of all, I think that's, it means that this, I would say, parting, yes, of DIFC and DLCA was some kind of foresightful, yes, in some way, even before this situation happened. But I wanted to ask a question. Can you tell, I'm sure it works fine, but just I think for the audience it will be interesting, because when I speak about arbitration institution and administrative cases, it's all about people and team who is doing this. Yeah. And we see here the beautiful guys from Russian Arbitration Center, administrative staff, who are doing it very well and professionally and efficiently. And I'm sure that DIFC staff is also working in the same way, and I had the pleasure and honor meeting some of them. But the question that I have is, as I understand, there are also many local people there, because if still there are people who are citizens of the UK or some other jurisdiction that has sanctions, they may refuse to act, and then in this case you need some local people who will step in, yes, because it's important. Sure.
Thank you, Andre, for that, and it's worth to highlight that in DIFC it's not only the judges there, not only from countries which is today is maybe is unfriendly countries, and though I think they will, if they take this decision or not to be participating or not to handle it, I think this is rarely will happen, because we have a strict regulation there on the DIFC. But if that's happened, that's not an issue at all, because DIFC has, if I'm not mistaken, 4 and still more to come, all the UAE national who is actually trained and practice under the common law, also as a DIFC law, and they did issue many of the very notable actually judgments on the IFC. So they have a capacity and they can be there. So that's issues of having judges which is from unfriendly country. That will not be an issue for the IFC, because there is a Emiratis guy which is they don't have any issues with a Russian company or individual or any parties. So that is definitely there, and believe it or not, most of the decision or judgments came actually, whether it is anti-suit judgment decision or freezing order or a decision on the main cases, it came from an Emiratis judges on the IFC. Which is, if you just look at it in their portal, you'll see a really nice judgment, and it's really drafted well, like any other judges actually. So that's something which is really positive for the IFC.
Thank you. Thank you.
Thank you. We'll now open the floor to questions. Lady in the front.
Thank you very much. Hello, dear speakers. Hello, dear audience. My name is Alina Sigalova. I am about to start the 4th course as a student, like a law student. I would like to ask about the recent amendments which were adopted in September last year about expanding the prosecutor duties in civil law and arbitral law. It's more for the lawyers, practicing lawyers in Russia. How do you assess this initiative that a prosecutor may be interfering and give his resolution about a dispute or a civil court procedures, and also he may decide to enforce a resolution by an arbitral court? And how do you assess the changes in the codes, legal codes, related to protection of Russian investors, assets and parties? How do you analyze that? Well, actually, thank you very much for the question. It is difficult to answer this question. I have not faced such examples in my practice yet. Maybe some of the colleagues did, but maybe somebody had such situations. But I think that irrespective of the number of the individuals who participate, the grounds to reject enforcement or to cancel an arbitral resolution should remain the same. And also, we should base ourselves on Russian legislation and also on the rules related to enforcement of statements and resolutions. If the court is accepting a new participant, so probably this party has evidence. Sometimes there are two speakers who appear during the proceedings in the middle, but it should not impact the final result of the proceedings. That is my answer. Thank you. I would like to add from myself that probably the main question is not who gets extra powers, but how this empowerment is being used. And, well, in general, a prosecutor, as an institution, he has a mandate which is simple. He is making sure the law is abided by, and he is the one to defend the law in the country. And if he's performing efficiently this function, if he's on the side of the law and he is party to the proceedings, for example, in this way he is supporting the Russian party against which there is an international there is a sentence of arbitral, there is a judgment by an arbitral court, and also there is violation of fundamental rights such as the right of protection, when the Russian party had no chance to protect himself, his rights and himself. Well, probably we should welcome such cases, but if the prosecutor's office is interfering in private relations of civil and legal character, which are not about order and law in the country, which only affects the private interests of individuals or companies, and these are commercial interests, this is a different story. Probably we should not be positive about that, because, well, it will be beyond their mandate. So the powers are neutral, and the use of these powers and the law enforcement has limitations, and we need to assess whether it was beyond mandate or in line with the mandate. Thank you very much for such an exciting discussion. You spoke about the choice of arbitrators, and it depends on the case. There is no one single answer to that. I will speak about a method, and I will ask about an exercise, which we should do that. Interview with the potential arbitrator. I would like to hear from Andrei as a practitioner, from Andrei as a legal advisor. Do you expect that from the consultants who represent your interests and from our colleagues from the United Arab Emirates and also arbitrators interviews, dear colleagues, what is acceptable in your cultural environment and how it is perceived by the arbitrators from the Middle East? I could start as the first person who was asked. Yuri, thank you for your question. I think in the first place we need to analyze the rules which are applied. Sometimes soft law is being mentioned here, but if it's in place, so we should check it. In difficult disputes, you could discuss that with the opposite party. If there is a shared desire, so the parties should have equal rights, and that could be done if both agree. I think there is advantage in that. I don't see that this is a bad practice if there are rules which are applied. If you agree with the other party, you align some rules around such preliminary interviews with arbitrators. So I'm not against such open communication, always better compared to closed communication. Closed communication is never good. In current situation, as I mentioned, in my experience, I think sometimes just being a very busy person, a person may not be just aware about something before you directly ask. All of these mass media or just watch the news too much, you read the newspapers in the morning, it really influences you. May it have an impact on the proceedings, because the proceedings, arbitral proceedings take long time. Well, probably such a conversation will make the person think, yes, probably it will be better for me with my subtle, sensitive, emotional nature to abstain from that. Maybe it should be understood at the initial stage.
You can go, you want to answer?
Okay, thank you. I can say by experience in Europe, for example, it is customary for parties to agree at the outset of the arbitration that they can confer with prospective arbitrators, and they can even confer with their arbitrator in respect to the appointment of the chairman. I've seen this used also in the Middle East, as many practices are taken from Europe. So I will say yes, this is customary in the Middle East.
Thank you, Rodrigo. I think I did actually practice it personally, because they interview me before they choose the arbitrator, which it was an agreement, as Andrea said, between the parties to each party. They can interview their choices before. So of course, with a very clear rules between them, they agreed what's supposed to be discussed, what's not. I think it was good, because I actually when I have a talk with them, then I understand that the matters how is it, then I said I don't think you're supposed to go ahead, because I should not be fit for this type of dispute. So even for me as an arbitrator, when I sit as an arbitrator, it is better for me to know exactly where I am steering. It's not a matter of just jumping on the middle of the ocean, and then, because you have a duty. You have, first of all, you have your reputation in the market. You need to serve the process in the right way, and you need to have that knowledge to help to reach the justice. If you are not, then it's not a pleasure only just to be sitting as an arbitrator. So I think that's a good thing, good practice, depending on the parties how they will really implement what they will agree. That is also something that's important. Thank you.
Let's listen to the client. What you want? All right, I want the process to go smooth, quickly, and get a good decision, you know. So, if I may, I'll switch into Russian. Ну да, разумеется,
Yes, of course,
максимально возможной,
as much as it could be.
регулирование, конечно, хочется заранее
So,
знать,
of course, in advance, one would like to know who we are going to deal with. I mean, the arbitrators. For now, while I was listening to my colleagues who were speaking about that, I was just dwelling upon the following. What could be the reason why I would reject such an opportunity of interviewing candidates to become arbitrators. I didn't find any valid reasons why not.
Излишне надеяться на результаты такой вот беседы. Вот единственное,
I think not to have too many expectations after the interview. Too positive interview may give you false hope and false positive impression about the arbitrator that he will act in your favor and you won't have to prove too much to him. And here there is a risk of expectations just to lie to yourself. And based on our practice of interviewing arbitrators, well,
в особом эмоциональный момент
well, despite anything, the arbitrators did everything they could, and also once we had the case when it all started, this political situation, the arbitrator, he just left the room, and he just rejected staying the proceedings. Nevertheless, we had a wonderful interview. And also the consultants, another approach, they're competing between each other. One type of people, they are trying to be very conservative, and they are not trying to select the best pro-investor arbitrator, the one who is mostly defending the arbitrators. They tend to choose the one relatively mild, who will inspire confidence and trust in other arbitrators. And also there is another extreme here. In terms of attitude, people try to be as much aggressive and push as they can, and they just try to select the one who will 100% support them, but also based on the assumption that we should not just have a discussion with ourselves. So we need to have a dispute with the other party, and we need to be as aggressive as we are and be aggressive in defending our interests. So this is the question which is very philosophical, and I do not have one single approach in my mind, in my head. Every time the truth is won in discussion. And I just recognize some of my colleagues when you were describing the two approaches, the two groups of people. Right. I tried not to do that, not to reveal my colleagues. Not to disclose them.
Я хотела также спросить немного в продолжении
So, going along the same lines of the previous question, there is anecdotal evidence according to which now during the disputes, when there is a party from Russia and there is a party from Europe, very often the plaintiffs and defendants want to come to an agreement regarding the arbitrator who will sue the both parties. So the case, the proceeding will not be will not take longer time, and the arbitrators will not be challenged. And I know that I have witnessed cases when the parties will want to come to an agreement regarding the arbitrator. Have that happened in your practice, or typically the parties act just like Michael described according to the second scenario? I will tell you, no, I have never experienced that. So far, we have not experienced any of this practice. Then my question should be addressed to Ali and Rodrigo. Is it popular in Dubai or in the Middle East region generally when the parties agree about the arbitrator to make sure that he will not raise questions for one of the parties, and then as a result the arbitrator will not be challenged later on during the proceeding?
I didn't come across that the parties, they agreed and not to do that, and because, as you know, they are enemies, they are fighting each other. That's very difficult, and then especially their counsel, they will say that you are killing one of our point later on. So I didn't see that actually, but if that can happen, that of course will give a better position for the procedure in the future. But I doubt it that something can be happen and accepted. No.
In practice, in my experience, we have seen now in the UAE as well as in other regions a practice which unfortunately is very common already in Europe or in the US, which is guerrilla tactics. So parties often where the weakest case on the merits use challenges strategically to delay the case, to obtain advantages. Those challenges often fail, and sometimes the challenge that fails can have very heavy effects on a party. Of course, an arbitrator that survives a challenge will be particularly minded in respect to the party that challenged him. But say under UAE law, the right to challenge arbitrators is part of the Federal Arbitration Act. So that agreement, I don't think, will be able to be enforced. And I'm afraid we have to close the floor for questions. So for now, I thank our excellent panel of speakers. And of course, we can continue the discussion over a coffee. I'm told we have 10 minutes of break. Thank you.
Thank you. Thank you. Thank you, Andrei. Thank you very much.
Раз. Спасибо большое всем, кто остался на вторую панель.
Thank you very much for everyone who has stayed for the second panel. And considering the fact that we have all the Russian panelists, we are going to hold it in Russian. And I hope that those who watch us online and our foreign counterparts will be able to listen to the simultaneous interpretation. So our first session was about the issues that the Russian business counter faces at this this point of time. And in order for us to have a smaller scope of issues, we decided to hold a second session and continue our discussion in order to mitigate risks that are faced by the Russian businesses and mitigate it to the maximum extent. Of course, you cannot get rid of them fully, and we understand that. We decided to discuss what can be done when including the arbitration clauses in the contract. And per our experience and per what we hear, we understand that what business takes into consideration nowadays, it has significantly changed. But when, as it always happens, whenever we find ourselves in a totally new situation, we do not quite understand what is the scope of changes that are applied for the arbitration clauses, and how this arbitration clause is going to work, and how the arbitration institutions will work under new circumstances. And in order for us to discuss all that, we brought together a great panel, and here we have the representatives of the legal firms. Here we have Vladimir Talanov, who is the representative of EPAM law firm, and here we also have the representatives of businesses. We have here Daniel Petruk, Senior Associate of CIBOR, and Maxim Mozgov, International Litigation Arbitration Disputes Director at Gazprom Bank. So I suggest that we have a live discussion, and I will address my question to the colleagues. And if you have questions later on, do not wait till the end. Raise your hands, and we will try to make this panel very interactive. This is the second one, so we want to keep it live. So, and by the way, I forgot to introduce myself. My name is Yulia Mulina, and I'm the director of the Russian Arbitration Center. Vladimir, from your point of view, has your approach to arbitration clauses changed over the past 18 months, and what have you faced? What kind of problems have you faced all in all? Thank you. Thank you. I turned off my mic. Well, thank you, dear colleagues. Let's continue the discussion that started during our first session, and indeed we find ourselves in a situation of an intrigue Michael was talking about. And if we talk about us, we were able to change the location of our arbitration procedure, and I can tell you that this was quite a challenge, but that was linked to the jurisdiction that is close to your heart, that is called Sweden. And you all understand the difficulties that Russian and Swedish companies counterface, and Russian banks and Swedish banks counterface problems as well, and the large international holdings that we would never suspect of any sensitivity towards Russian process, but even for them, it was clear that such words would make controversial, and we have read a lot about it in the doctrine, the books, the textbooks would tell us that something may happen, let's say, something happens to the planet, but now we have our current reality. And the main problem for us to understand where to relocate the arbitration proceeding. And as Julia said during the coffee break, unfortunately, right now the Russian parties believe that the relocation can take place anywhere unless it is a non-friendly country. And I can tell you that it's no secret that we have a great resolutions in favor of the Russian party from the BCC that supported Russian public company when there was a dispute between the Russian company and the Finnish company that happened in August 2022, and there were no problems whatsoever when it came to biases. There were no problems related to that. And same when it comes to PLC. Everything works really very fast and the money
сказать, что мы прямо
is wired,
совсем столкнулись с какими-то
arbitrators
нерешаемыми
are
проблемами,
appointed, and there are,
не сказать.
I cannot tell
Поэтому,
you that
может быть, и не всегда их нужно
we
уносить. Но если все-таки
counterface
уносить, какие
problems that
основные мы
cannot be
рассматривали истории за
resolved. But
последнее время,
in any
понятно,
case,
что,
if relocation of
первая мысль
arbitration proceeding
это
has to take
Турция
place,
и
you
Дубай.
think where can
Турцию
what
коллеги критиковали.
location can it be either Turkey or Dubai? During coffee break, many of the colleagues criticized Turkey, saying that the local or arbitration
Но я уже говорил о
trials
том, что у нас в Турции есть положительный опыт.
do not work in favor of our companies. However, we have quite good experience, and a lot depends on your local consultant. And here, I'm not talking about any corruptive component or anything. I'm just talking about your understanding what court or what tribunal you have to appeal and what type of hearings will take eventually place. As for Turkey, our clients feel doubtful about their political situation. On one hand, this country acts in a friendly way at this point of time. However, it can change, and some of the clients waited for the presidential elections and their results before opting for that location. So I cannot tell you that there is a unanimous feeling about Turkey. Dubai is a great option, a really great alternative, and many clients look at this location and include Dubai in their arbitration clause. Maybe some of them still feel cautious because you don't want to deal with English law, and sometimes, depending on the case, you don't need it. But if there is a common law perspective, in that case, it's an optimal way to go.
And also it was included in some of the contracts are in the discussion, and there are Asian location, Asian sites. We are lucky. We had many proceedings and disputes in India and Asia. We have 10 years of proceedings in India. India may be a wonderful place to prolong a dispute so that nobody can do anything against you. There are no resolutions. There is a center of arbitral center in Malaysia. They have such tricky rules that in life, in practice, it's never clear how it's going to work.
В зависимости от тех нужд. К сожалению, должен признаться, что далеко не всегда сейчас клиенты подписывают.
Not always the clients, when they sign the clauses, they would like to efficiently to be brought to justice. And also, if we are defendants, then we should just think about the clauses and sites where we could prolong it forever. This is what we've been doing recently. Thank you very much. Talking about the sites of arbitrage, you're trying to change it, right? And changes to the institute, to choice of institute. I hear from colleagues that somebody started to change the institute, and they just were using, some others were using the same. And I tend to agree with Vladimir. The awful, horrific stories that we hear about foreign arbitral centers should also just do not accept literally, because this is about the survival, and we do not have the real facts. We just only hear about cases which were not smooth and not about the positive examples. SCC, we agreed with them. It's very difficult with the payment. And also,
где они скажут, извините, ну никак не проходит, они никогда нам это прямо не указали.
They never said directly that they cannot accept the payment and the money would go back. But as for ICC, we managed to solve all of the problems. It's all working.
Спасибо большое. Я вижу уже вопрос в зале. Давайте, Анастасия.
I see a question?
Анастасия, подождите секунду, чтобы вас
Anastasia, one
выпустить.
second.
Нам нужно вам принести микрофон. И фотограф тоже. Все включено.
Вы сейчас видите рост установления требований национальности?
And also nationality of the arbitrator. Do you have this
Есть, наверное,
requirement?
пытался вспомнить, сколько таких ситуаций.
And
Я думаю, что у
I'm
нас
trying to remember, I think we have 5 cases in our portfolio where in the first place we agreed about the initial disputes not to give them the chance to dispute to apply the chair, and also it was done upon agreement, and they accepted that. We have the maps of the world where in red we have the jurisdictions which are not okay for both parties, and these maps, they look dramatic. India, China,
Cambodia,
Bangladesh, half of Africa, for some reason, they are considered by our Western counter-regions. They're considered to be aligned with Russia. We would be happy if they would be, but it's not true. So we need the countries which did not introduce any sanctions against Russian citizen companies, and there are very few options left.
У нас есть, это не наши дела, но мы знаем, что есть параллельные треки.
And there are tracks in parallel where ICC would apply the leading arbitrator, and also we recommend all of the clients to write the letter to the opposite party to exclude the chief arbitrator from a friendly country. And ICC, based on the current practice, they do not appoint arbitrators from unfriendly countries. These may be people from Latin America, South America, whether it's good or bad, I don't know. One arbitrator we applied, we assigned, so she wouldn't like to have a no-name arbitrator.
Здесь и для арбитров есть ощущение, что лучше бы договориться, чтобы получить...
So also it is better to get a person they're confident in, and the parties are also more motivated to come to an agreement. And as of the nationality in the disputes, when we clearly stated the request to take that into account, was not always accepted by the opposite party, but in all of the cases we managed to come to an agreement about the candidate. Thank you very much, if you allow me. Maxim and Daniil, do you see any major changes in the selection of the site and institute? If yes, which ones?
Давайте я начну. Действительно,
also, for us, all of this situation just put us in a suspension, and
начало приносить нам неожиданные сюрпризы.
We started to get sudden surprises, impossibility to pay, and the real difficulty to engage a consultant, despite no sanctions applied on the company. We actively work with different consultants, but we regularly face issues with finding consultants, and also we have issues with the payments. And finally, we are forced to look for new jurisdictions, and also, if the criteria were quite standard, so the speed of procedure, special procedure, accelerated procedures, and urgent arbitrator. And now the main criteria is neutrality or unfriendliness of the jurisdiction, because these difficulties are very practical, down to earth and everyday issues. If we have a range of projects where we cannot find a consultant, we will try hard to move away from that jurisdiction and act as a business years, and we'll try to mitigate those risks for the future. We don't know what is going to happen in 2 years, and we have the standard clauses that we signed years ago. The clauses which we are signing now, they are going to be effective in the future, and we are in suspense. And we try to select from the jurisdictions and arbitral institutions which inspire certain trust and confidence. We suggest Russian institutions. Unfortunately, our foreign colleagues do not support us quite often in this suggestion. If they mistrust Russian jurisdiction, it's understandable. We could not come to an agreement to use Russian jurisdiction. We tried to use Hong Kong due to several reasons, because it's neutral in the first place, and it gives the possibility to engage local consultants. And Hong Kong has agreements with the mainland China, which may simplify enforcement and execution of the resolution. And also, the institutions, they really understand sanctions. They have sanctions rules. If they select an arbitrator, they try to appoint somebody from friendly jurisdiction. It's close to Commonwealth, common law. This is why we believe this is quite a neutral jurisdiction, and we suggest that as a second option. Unfortunately, this option is not always accepted as well, and our colleagues from China are unwilling to move any disputes from China. Even Hong Kong arbitral court is rejected by these colleagues. So that's why we end up in India, and we disagreed. Just given the story by Vladimir, we will never accept that. Turkey, we would consider it as a specific case. This is the jurisdiction that we know less. Still, we do have business with this country. So this is the order in our list. If we fail to agree, we try to use alternative cascade clauses to mitigate the risk of complete unpracticability and unfriendliness. Sometimes it does work and helps us to select the institution which is okay for us and the other party, and what we are going to do in 2 years. So let us see. This is how we change our approach. Actually, that was my next question. Yes, the other countries which have relations with companies which are under sanctions and or run the risk of being sanctioned, it's better for them to use a Russian institution, but as a defendant, it's better to be abroad. I was always surprised why alternative clauses are not always popular. Have you seen alternative clauses? So from whom this will is going? Of course, we are trying to do this, but we cannot offer Russian institutions, and we select between international ones. No, I just mean that you are shooting yourself in the foot for foreign companies. But as the law enforcement practices in Russia, there is a huge difference between Russian judgments and non-Russian judgments in terms of law enforcement and enforcement of the resolutions. Yes, dear colleagues, I agree with you. Many things have changed. The approaches are being changed starting from 2014. 2014, we started to use Hong Kong. We had such clauses.
Сейчас актуальность достаточно высокая.
And it's very relevant to have different institutes. We already mentioned St. Petersburg. I would not have risen this topic, but what is more important? The arbitral proceedings or the jurisdiction, the law to be applied. Just imagine the British law, will the arbitrators agree not to apply the sanctions in place? And this is a big question mark here. Let us bargain and we'll have the Commonwealth law, the British law in the contract. After that, we will go to a different court. No, it won't be good in France when they accept foreign resolutions. They have the international rules. If Russia was cancelled for some reason, yes, it's in place, but it was accepted by the country, but so this is the first question, which law will be applied, and also some friendly countries, and should be Russia. We always maintain that. Sometimes the party is the most interested in the contract, but the applicable law is the most important question. But still, there should not be unfriendly countries. There should be at least a neutral Soviet republics, probably. Also, the law of Hong Kong, we have such cases. The applicable law is what matters here, and it's crucial. When we are selecting the regulations and the seat of the arbitral proceedings, and also there is some place for bargaining, and also we could use direct clauses. So that we have less appeals. I don't know, seat or regulations, what comes first. And also on this depends how we are going to pay. And also the supervision of the proceeding will depend on the site. And also, we could use that for bargaining. And also the judgment dated July 7th in St. Petersburg, I would like to comment. You could just
нейтральным статусом. Сейчас сторона, которая хорошо подкована,
be ambiguous, and if the opposite party has consultants and knows the Russian practices or law enforcement, so they may be aware of our tricks. And also, let us see what will happen, whether there will be appeals or not. Also, there were ideas voiced about lawyers. Yeah, that's difficult to find lawyers in cases of unfriendly lawyers, especially. We have also we have qualified solicitors as well, and we have a practice of payments in rubles. If everybody is moving to national currencies, our consultants must understand and accept that we could just offer local payments in local currency, and we have such cases.
Я хотела, кстати, дать
Yes, by the way,
обратить внимание
I would like to draw your attention, clarify about
тогда у Данилы и Владимира тоже. Я правильно понимаю, что речь шла именно о праве применения
based on
политического, да?
merit.
Я правильно понимаю.
So, yes, you were talking about merits of the case, right? And has it changed in the contracts? The law? Have you changed your principles in drafting the contract?
Оно очень разное было, и оно разным и осталось. Честно говоря, очень зависит от существа сделки, поэтому я...
So, it depends on the deal.
Мы действительно уже, наверное, с 2014 года всегда стремились перейти, раньше уже начали.
Starting from 2000,
по максимуму, если возможно.
14, we started to move to Russian law, and it depends on the situation.
Где
we have a dispute
такая хитрая, что мы очень
where the contract is so tricky only for British judges, for British arbitrators that should seem surprising for continental lawyers. It is something common, and even on purpose we would like to have a continental arbitrator, so here it's an important factor. We try to start from Russian law, but probably this is not a recent change, a change which we introduced over the recent years. We started to do that before. Here I would like to comment that the choice of material law is less flexible compared to the site. Because the substantive law of substances is mostly related to the relations between the parties. And also there is such a trend, because we are talking about different nature. Yes, this is important, I will agree, but you know, this is more neutral.
Ну, у меня просто почему этот вопрос возник еще?
Why I have this question?
Например, в российском арбитражном центре.
Because, for instance, in the Russian arbitration center, there is a rule. If we talk about a single arbitrator or presiding arbitrator, we cannot intervene. However, we can provide some guidelines to other arbitrators, and the arbitrator is selected from the neutral forum. And if you talk about a Russian arbitrator, at some point of time, you have no more neutral arbitrators that for non-Russian that know the Russian law quite well. The Russian law is more specific, and my question here, whether you have contracted this issue of selecting an arbitrator. I understand that we get back to the discussion of the previous session, but I hope that's fine. Yes, we have faced that, and I cannot tell you that a pool of arbitrators or large-scale arbitrators that is large, but it is there, and I cannot say that there are no arbitrators of that kind, and it is possible to appoint arbitrators, and it is a very important matter after all. If you think of it, you want the arbitrator to be well qualified in the Russian law, but and at the same time he or she should be well respected among their colleagues, and even with his credential and even with his appearance. But I can tell you that all in all, when it comes to the arbitrators, there is a good trend. And now, as I talk about it, I'm thinking about one arbitrator who is a great expert in the Russian law, and we often ask for his service. And there are foreign arbitrators, female arbitrators, who are more willing to work with the Russian sanctioned parties. At least that is common for us. And that may be a double blow, because on one hand, these ladies are charming and they add a certain touch to the arbitration proceedings, but they're also ready to take these cases. So my case with female arbitrators is positive compared to male arbitrators. arbitrators in terms of their appointment. That is quite interesting because women are very courageous and they want to defend the truth. It's good, and unfortunately here we don't have representatives of Russian women in arbitration, but we will send a message to them. And actually I understand what you're talking about. Yes, women can be more courageous sometimes. So for women it is quite typical. How about you, Daniel and Maxim? Have you faced that challenge? What do you do when it comes to selecting an arbitrator? Not necessarily when it comes to the Russian law or more or other law, if it's not a British law. When we agree about the arbitration clause, for instance, everything can look well, but when you start working with an issue in practice, you don't want to have too many limitations. If you allow me, I'll tell you the following. Many institutions have this limitation. There are institutions who have this rule in their set of rules, and anyway, I can tell you that we have not experienced any challenges, any difficulties in appointing our arbitrators. Same for us, but I think this overall is a question that is worth discussing, because there are talks that there should be some restrictions when it comes to selecting arbitrators from non-federal countries. But again, how would you find an arbitrator who is well qualified in certain law and at the same time happens to be in a country that is Russia friendly and will be qualified enough? And we believe that excessive restrictions should be avoided, and it's better to choose arbitrators by means of your own research, and let's look at the publications of arbitrations, or even try to use your own sources. And any restriction and limitation can be hurdle. This year we decided not to resort to the services of a certain arbitrator who liked a publication that was not well liked by us. So we even look at the likes in the mass media, where in mass media where they are like or dislike certain publications. Well, this is quite a popular story when you track publications or likes or dislikes. And I think this is an issue that is experienced by arbitration institutions, because they have to appoint their arbitrators more often than the country. So another problem is that we never know what is nationality. After all, what is a nationality? Where you reside for half a year, especially now. There are many individuals who live in a particular country for a year. So do they belong to that country, or are they the nationals of the country where they used to live, or they're going to live, or where they have citizenship, and so on. Thank you very much. By the way, I have one more question about the applicable law. You have mentioned that when it comes to applied law, a lot depends on whether the arbitrators will execute or not the sanctions. And I think an additional event can be held to discuss that issue. And actually, nobody knows, and there are so many factors to consider here. And talking about sanctions, if you look at Lugovoy law, it is something what we have to abide for. And of course, the clause has to take that into the consideration. Have you experienced problems, or do you, let's say, if you work with a Russian institution, do you agree to have the foreign location of arbitration proceeding, or vice versa, if it's a foreign party, to have a Russian location of proceeding? Because it is something what we have to take into consideration. How do you interpret that, and what options do you have here? I understand that that may not have to do with the sanction cases, but again, considering how many sanctions are imposed every day, you need to take it in consideration anyway. For the Russian parties, it's convenient to use a review that was issued in 2021, and so when there are sanctions, they already limit you in your opportunities, and you're not in an equal position, and you don't have to prove a lot there. Yes, therefore, the Russian parties use this instrument, and you need to use it in a responsible way. So think when the relevant issue arises, so that instrument is there, why not use it? So in other words, when you deal with a foreign institution, or when you use, or when you look at the location of the arbitration proceeding, well, it's a very good question regarding the location. For instance, you're talking about a Russian proceeding, but, well, actually, it is a very egoistic question from me, because we were always interested in whether potentially you can use a Russian Arbitration Center as DC for such disputes, or again you are limited by this. The question with the IFC is not settled yet, so you don't know whether you can relocate it according to 248.1, and as for relocating from non-friendly jurisdiction, relocating the proceeding, well, if you follow the common sense, there is a logic there, because there are supervisory bodies that will look at the word, will evaluate it in terms of the public order. So maybe from arbitrational standpoint, there may be no problems. However, when it comes to supervisory bodies, there can be some problems, but it's a very individual thing. You need to look at it case by case, so you need to see what will happen to the case in future. For instance, if there is only a seat there, and you will have to prove that it is impossible to consider the case. So there, I always get ready for the worst. I read it the way it is there. Everything what is beyond the border of the Russian Federation is covered, and therefore, for me, that decision was not a surprise. It was logical. It could be predicted. After Pesach's case, it was clear. So be it Hong Kong or Dubai, it does not matter. It's written there beyond the border of the Russian Federation. If it's a foreign institution on the territory of the Russian Federation, it is more tricky, but it says it should not be. And so you need to read it the way it is written. But of course, it's our interpretation. But I think it should be interpreted only this way. And this is the worst case scenario for your future award. I will support Vladimir. Why should it be or? It depends on which side we represent, which party we represent, and depending on how this article is applied today, you can expect anything and everything. The article is very politicized, and even if you're not under the sanctions, still it can be applied, and I think now we should not expect any certainty, because it is worded in a very dubious way. It can be this or this way. So if you believe that it should be relocated, it will be interpreted in a way you want it to be. But if we need it, then why shouldn't we try to use the tool? Because it may be beneficial for us. Because so when acting as a lawyer, you need to understand understand what party you represent. True. I also have heard about options of using this article in a very extended way, when instead of arbitration in Russia, the Russian institution had to apply the foreign law, and in that case you will need foreign consultants, and if you cannot use the foreign consultants, that means that you already have sufficient barriers for your opposition to be heard. Well, you know, this interpretation is quite scary for me. While it can be done, yes, the wording can be amended. No, don't talk about it, Vladimir. In that case, it will be very rigid way to interpret that article. The next question, considering the fact that we will have to switch to Q&A session, or I'm not sure whether there are any questions left, but anyway, if you include the arbitration clause, I understand that all agreements are individual and it depends on which party you represent, but if you differentiate between the institution, the allocation of arbitration and the applied law, what are the concessions that you are willing to take? Do you understand what I mean? Okay, absolutely. Everybody has thought about it, correct? Well, if you allow me, I think from my short speech it was clear that the applied law is number one, and then seat and institution are equally important factors. I will agree with my colleagues, and I can say that if you think of venue, it can be compensated at the stage of consideration, at the stage of choosing the arbitrator. Such shortcomings can be compensated, but as for shortcomings of the applied law, you cannot compensate it so easily. So this is the number one priority, and with the other factors you can be more flexible. Yes, the applied law is the most important factor, and then seat may be more important, not the institution, because you may resort to for the assistance of the local courts, and of course then you need to look at the balance of risks of the institution, but the venue and all the difficulties related to certain jurisdiction make me think that you need to be more cautious. With institutions it's always possible to work and come to terms. All right, thank you. So I suggest to start the Q&A session and give the microphone to anyone who has any questions. Well, and if there are no questions, it means that our speakers covered this theme quite substantially. Hello, my name is Maria. I'm the junior lawyer at MCS. Thank you, organizers. Thank you, speaker. It's very interesting to listen to these experts who's publishing you read regularly, and as one famous movie said that we talk only about anti-suits in a Russian way, and I would like to understand what you think about Kazakhstan as a venue and as a center. On one hand, there are some advantages like the English law, and on the other hand, this country is not really aligned with Russia, considering the recent political developments, so there is certain trust for that venue, for that location. But would you recommend Kazakhstan to your clients? What are the risks and what are the obvious advantages? As for payments with Kazakhstan are quite easy to do. Thank you. We do have experience or an attempt to choose Kazakhstan as a venue, but unfortunately we were unable to convince our counter-engine in that, because unlike us, Kazakhstan believes that our counter-agent believes that Kazakhstan is the best Russian friend. Maybe it's not so, however, what we understand that this is the reputation of Kazakhstan among our agents, but I believe that in that particular case it really made sense to use Kazakhstan as a venue for arbitration, but it did not work out.
Если можно присоединиться просто к этому вопросу.
If I can join this question, but maybe you could talk about other Central Asian countries apart from Kazakhstan. Was there experience of using the Central Asian countries as a venue for arbitration? No, we do not look at those jurisdictions. We have had discussions, but I'm not ready to voice the results of those discussions. All right, thank you.
Thank you. So we discussed changing arbitration clauses, changing the venue of arbitration, arbitral institution, and governing law. In some industries, it's more common to use international courts rather than arbitration. For example, we have a representative of the banking industry here that might act in that respect, and traditionally those disputes go to the English courts. Now we had here a discussion about Kazakhstan. Kazakhstan has the AIFC, which is International Free Zone, with the special international courts as much as like the DFC and the Singapore international courts. So has there been a discussion about changing the governing law from English law and using international courts different from the English court in such instances?
Of course, we have discussed that when it comes to the applied law. Of course, we have discussed that, but when it comes to the specific law in the economic zones that exist, such as the DFC law, this is quite a challenging issue. If you're talking about banks, banks are quite conservative. And when it comes to changing the law to something that we are not well versed in, that is not an easy thing to do. And there should be quite many arguments provided to us to make this decision. But as for the English law, we are not at great terms with it either. Yes, when it comes to certain industries, we understand that no matter how you treat the risks, but when it comes to shipments, you use GAFT and you cannot go without it. When we try to discuss changes with colleagues, they are reluctant to any changes because they understand how the current conditions work. And unfortunately, in some industries, there is no alternative, or an alternative would take lots of time and effort, and therefore we want to be able to convince colleagues.
So there was a question here, dear colleagues. Thank you for sharing your experience. This is very valuable. I'm a practicing lawyer, and I have a question to all of you. So the applicable law, for example, you fail to agree with the company, the Chinese, they don't want Russian, you do not agree to have the dispute in China. And also, these are the contracts for product supplies. Are the parties ready to consider the soft law, like international contracts, or so this is a mythical tool talking about SIP, and probably this is the SIT. So, are you ready not to demonstrate that? All of the institutes they demonstrate and they recommend that, but it's not being changed because, you know, the friendliness of the countries, they tend to change every day. 2 years ago, if you asked me if I recommend ad hoc arbitrage, yes, and SIT should always be there. And when there are conflicts, or you fail to agree, well, sometimes it could be aligned at the time of dispute, or you come to an agreement, or all of the parties agree, but I had that. The arbitrators, they are going to decide upon the location, the site of the proceedings. Your question is about ad hoc. Just could you clarify your question? No, there are two questions.
То есть, вот вы говорите, там сложно банку выбрать право, которое он не знает.
So it's difficult to select a law for a bank that you don't understand, but which is the law that banks understand, because you cannot suggest Russia for all of them, but if these are the people who are in Russia, yes, of course, they do select that. But in order to remove and sacrifice unfriendly locations or sites, probably that's a good option not to include that. Non-droit, this is the question. I had just this experience. There are not so many supplies to the banks. The contract specified this. Also, the applicable law was identified whether based on the following criteria, where the supplies were going to and from where, and they decided that the principles will work. The parties failed to agree. The applicable law, we are going to identify it based on the common principles. The lawyers should not lie to themselves. When we specify the common law and the arbitrators will decide upon the applicable law, no, there are collision rules and norms. So that was about the applicable law. As for the site of arbitral procedures, yes, you could lie to yourself if it's institutional, like the IFC, for instance. Then without specifying the site or sit, we don't know. Talking about ad hoc, just to give it to the arbitrators to decide, that's scary, to be honest.
About UNIDRO principles, we had a story where a very respected arbitrators, Peer just seemed to ignore those rules, despite that the parties were telling him. The arbitrators dislike that probably. They want a firm and understandable, applicable law in terms of interpretation by national courts, and I would not rely upon that. I completely agree. As for the seats, we on our side, we just, if we don't specify it now, we could realign, we could change that. If it's not decided upon, who will decide about this? Are we ready to just say no to this opportunity? I think it should. It's better to be specified from the beginning. I am talking about legal risk management, I think, here. When you just plan your work in advance, if you could mitigate the risk of uncertainty for the future, I think it should be done. This is about SIT and the applicable law. If we are facing some specific jurisdictions such as China, that we understand what is China, but Chinese law is like, somewhere in outer space. Here we could be talking about adding something else. But in general, it's about legal risk management. We should mitigate the risks with the help of certainty. I mean, we should specify that in advance and have that regulated. That will be the priority. If you allow me to add about the seat of the arbitral proceedings, many clauses not specify the seat, and our regulations do not automatically specify. Unlike London MCAS and others, the arbitrators, they decide. It depends usually on the arbitrator. If it's only one arbitrator, he will not look at the parties often. When he is selecting the seat, he will select the one which is convenient for him. Probably that could be good when both parties are not satisfied. It's kind of a
compromise, but this relation between the dispute and the side, so it could vanish completely. And there is a well-known case where the institute appointed the arbitrator who was not related to the jurisdiction, not with the applicable law, not with the seat of arbitration. He was from Switzerland, that's why he was appointed. And the institute, they trusted him. And in this case, let us not go into the details, it was about a CIS country, all of the what he could select, all of the elements, they were to his favor, and none of the parties could understand what was happening. It's also possible. About the second question, just adding to Yuri's question, paraphrasing it a little bit, even given we need risk management and we all love certainty more than uncertainty, how often there are conversations around applying ad hoc arbitration with regulators, because the mechanism to be more flexible, it is more adaptable to the parties. If there were such discussions, yes, over the past year, not so many of them, yes, more often than before. Yes, probably we could speak about such a trend. Whether we came to an agreement, no. The clause were not accepted, but there were discussions around that. No, not here. No. Another question from online. I just will paraphrase it. The colleagues are asking if we take the Turkish Institute of Arbitration, which already has a status in Russia, or the Dubai International Center of Arbitration, which is also certified in Russia, and other friendly institutions, will it increase the value of such institutions and the probability of you to include it onto your list? Is it important for you that this institute is certified? Yes. Yes, it's one of the factors of choice, criteria of choice. Take an exotic jurisdiction that we have less experience with, but where the institutes, they have our certificate, so that is better for us. Well, I think that's just the beginning.
Есть ли еще вопросы аудитории? Михаил.
Mikhail, more questions from the audience.
Спасибо большое, коллеги, за интересное.
Thank you, dear colleagues.
У меня вопрос, наверное, сугубо такого практического.
I have a more practical type of question, probably in everyday basis to Daniil and Maxim in the first place, and also to Vladimir. He will have an opinion, I believe, and I assume we are all here.
В существенной степени специалисты в области
we are experts in arbitration, and we are discussing the details.
Волнующие вопросы.
How to identify seat of arbitration, what is the applicable law, 3 arbitrators or 1, so we are going very deep into this topic, discussing it, and we deal with arbitration tribunals. Your department of contracts and your business, you are aligning those conditions very quickly, and you have the last question. This is the clause about arbitration, sit here, not sit here, what to choose, what is the applicable law. How do you solve that? Do you have a systemic approach? People come to take your opinion, to discuss it in detail, or just in practice, you have a framework. After this framework, you do as you wish, and then you change. But what you do in order for the people who are drafting the contracts are more aware of the importance of this issue. Vladimir, you're a specialist in arbitration. Do you have practices in your company based on contracts? Do they come to take your advice, or they don't do that and afterwards you provide your consultation? Probably, being a banker, I will reply, well, of course, in the banks, these risks are being assessed. There are regulations in place, how the business should work. Of course, the business people, they have their role positions, and the legal people, they just worrying about the risks. But we all need these contracts, and we are pushing at our positions and our levels. It all goes around risks. From time to time, we have such cases. There are no gaps here, no failures. Good for you. Going back to my previous speech, we have a system in place. We have all of the rules. If it's like that, we do this. So we have instructions, we have guidelines. So we have the framework in place. But if our counteragent, our contractor, just don't agree. He doesn't agree, but we work with people from the Department of Contracts. If we have the standard situations, then we are not so deeply involved, and we describe them the risk if it's a non-standard situation.
Мое направление мысли, потому что действительно у нас фирма-то большая, и практики разные, и контракты пишут люди другие.
So, different people, they draft contracts. I've been working for 16 years in the company, 10 years I was fighting with corporate practice department people, so that we had a case with the British law. No, I do not always vote for arbitration. Sometimes I vote differently. I don't always support it, but here there was this case. Yeah, first you need to describe, to picture, so that they picture all of the horrors they will have to face, and on the weekend and at night we were just giving them standard solution and clauses. It was never enough for them. Now it's going to the other direction. Before we give our case, they do not align anything. We are talking about perfect balance, but here the balance has changed. You did not ask me, but if you allow me, I will comment. I'm very happy for Vladimir and his company. I'm not going to give the names, but corporate practices sometimes are not used, so they go to institute not to use the arbitration practices. I mean, the corporate departments. Do we have more questions, dear colleagues? So, to be able to answer this question correctly, I could tell you that. So we have reception and champagne. And no questions, right? No more questions. Everything became clear. If there are no more questions, if you have questions, we are going to discuss them later. Let us thank our speakers. I think that was an exciting session. And we invite you to the garden, because this is a real garden. First we invite you there. After that, we will go outside. It's not so hot. And we are offline already, I hope. Thank you.